Fast. Good morning, everybody. For those of you who were not here yesterday or don't remember yesterday, my name is Richmond, and I am with Harness, Dickey & Pierce out of Washington, D.C. We've been around for about 100 years. I have about 120 lawyers. My background is mechanical engineering, which is where this discussion comes from. Nonetheless, even though it's a mechanical engineering originated discussion, the things that I'm going to talk to you about today are applicable to just about any technology you can think of. Why are we here? A couple of weeks ago, or why am I here? A couple of weeks ago, I moderated a panel at the U.S. Patent and Trademark Office. The American Intellectual Property Law Association had a partnership with the USPTO where it was the U.S. Patent and Trademark Office's tech centers 3600 and 3700, which is primarily mechanical engineering, but it also covers business methods as well. And can everybody hear me back there, by the way? Okay, great. It also covers business methods as well. That panel actually shared the same title that we have today. The reason for the panel was to give examiners an insight into the mind of the patent practitioner and give the patent practitioner insight into the mind of the examiner. Part of the problem that I've seen and that other practitioners have seen and probably examiners have seen is that there's a chasm between examiners and practitioners. There's a divide, a pretty big one. And we wanted to try to fill that gap and see if we could come up with the reasons for the divide. There are actions that practitioners take that make examiners go crazy, and there's actions that examiners take that make, did I get that right? Actions that examiners take that make practitioners go crazy, and actions that practitioners make that make examiners go crazy. So we wanted to try to fill that in a little bit. Both practitioners and examiners contribute to the chasm. Practitioners contribute to it by having one eye on the present and one eye on the future. And by that, what I mean is having an eye on the invention while also having an eye on litigation. And that's what we as lawyers do. I mean, we're trying to prepare for something that's coming up in the future. We're trying to prevent our clients from being harmed in some way in the future. But that is, in some ways, at odds with what the examiners are trying to do. The examiner's intention is to examine a patent application. They don't care nearly as much about litigation as we do. So, but the examiners do contribute to that chasm as well. They contribute to it by doing what the patent office tells them to do, which is their job. Sometimes they will have an internal seminar that we don't necessarily know about as practitioners, or they'll have a discussion internally that we don't necessarily know about as practitioners. What happens is we receive office actions with certain rejections that seem a little foreign to us, unfamiliar, just strange, and it's maybe, you need at least 2 data points to make a trend. So it'll be the second office action that we'll see this out of this abnormal, what seems to us an abnormal rejection. So if we're getting changes or these seminars are happening internally at the PTO, say every 3 to 4 months, and excuse me, Tony, I know that we discussed this yesterday and you addressed this, but if we're getting if we're getting updates every 3 to 4 months and it takes us a couple of office actions to realize what's going on, if an applicant's portfolio is spread around among a number of firms, or at least a number of attorneys, there might be a dozen or so office actions before you realize that there are some changes that have happened at the PTO. So you're talking, $10,000 or so worth of responses. And if this happens a few times a year, now you're getting up into the $50,000, $60,000 range just to account for the changes at the PTO. So that's kind of what we're trying to deal with. And probably what I should have done, that title was the same title that I had at the partnership meeting. What I should have done was call this greater context, less cost, because essentially that's what ended up happening. You'll understand that in a minute. To prepare for the panel, we talked with a number of in-house counsel around the world to get their complaints about the U.S. patent system, what they wanted to see addressed. We also talked to examiners about their complaints about me, about U.S. patent practitioners. Some of the things that we discussed that day and some of the things we discussed with the examiners and the practitioners include things like how patent applications are written, how patent applications are examined, how drawings affect an examiner's interpretation of an invention, how that contributes to increased cost, delays in prosecution, how claims are presented. We also discussed some things that aren't up there. We're going to talk about these things now, but we also talked about how references are presented to the Patent Office, how interviews are conducted. Those things that are relatively routine, but nonetheless tend to slow down prosecution and increase the cost of prosecution. We discussed all those things, and we did not go into the substantive topics like anticipation and obviousness. We could have talked about that for a week, and we could have talked about these non-substantive things for a week. So we focused on the non-substantive issues. Applications, let's start there. So in examining the chasm between the examiners and the, I feel like I'm going in and out here. In examining the chasm between examiners and practitioners, we started at the beginning with the invention. So we figured from our discussions with both parties that it's best if we can work together as a team. So if examiners understand why the invention exists in the first place, why are we coming to the patent office then to get coverage for patent coverage for a particular invention, the examiners are more willing to work with us. Not just to give us a patent, but to give us the kind of patent that we're interested in. So for example, if an examiner understands that our client or that the applicant is maybe a little late to the game and is trying to build their portfolio, an examiner is more likely to suggest allowable subject matter that we can just take with ease and maybe file a continuation application on the more problematic subject matter to argue at a later date, because they know we're interested in building a portfolio. Alternatively, if an examiner understands that we're trying to protect a product that is recently introduced into the market, an examiner is more willing to focus on the base reference in a technology, and by base reference what I mean is that reference that is cited against just about everything in that particular art unit. Now, knowing that introduction into a patent's purpose, it really depends on who you speak with. So examiners, one of the hang-ups that we have with introducing subject matter to the patent office is that applications vary based on the practitioner. So a practitioner will understand the invention from the inventor in a number of different ways. One practitioner may look at drawings and say, okay, now I get it. One practitioner may look at a process and say, okay, now I understand the invention. What will end up happening is if the drawings are what causes the practitioner to understand the invention, then the practitioner will usually start there with the application drafting. Similarly, if the practitioner understands the invention from the way the invention is put together, then you'll see the process featured prominently in the application. What we as practitioners have to understand, at least based on the conversations I have with the examiners, plural, is that examiners don't get their understanding of the invention the same way we do. So every part of the application is important. Every part of the patent application requires its own strategy. So in the interviews I had with the examiners, I think just about every part of the application each examiner looked at a different part of the application first. So the first guy shocked me. So he looked at the abstract first. When he picks up an application to review it, he first looks at the abstract. In some art units, that's fine. I mean, in the chemical arts, it's probably a little bit more accepted to see that an examiner is going to go to the abstract to get a feel for what the invention is. In the mechanical arts, it's so foreign because it's so easy to get an understanding of the invention from looking at the drawings. So when he said he looks at the abstract, I'm thinking of how shocked I was, because a lot of practitioners kind of look at at least in the mechanical arts, will throw in an abstract at the end. They'll say, okay, I've written my application, I've written my detailed description, I've written my claims, I'm set. Let me go ahead and put my abstract in, and just to meet my requirement to have this section. But now that we know examiners will look at that, we know that it's no less important. So every aspect of the invention of the application is important. Another examiner looks at the claims, which you would understand. Another examiner looks at the drawings first. Another examiner starts at page 1 by reading the title and the field of the invention. I mean, it sounds crazy. So the takeaway is that everything requires its own strategy. I'm going to cover a couple of things that color the examiner's opinion of an invention. What I'm getting at here is that the first thing that an examiner will look at will really, if it's, no matter what it is, that sets the examiner's opinion of the invention from that point forward. So, there it is. Okay, so let's talk about drawings for a second. What we determined from our discussions with examiners and from practitioners is there's a whole spectrum of drawing disclosure that you can present to examiners. So on the minimum amount of detail side, you have to present drawings that show every element of the claimed invention. On the maximum or overabundance side of the drawing detail scale, you can present drawings that are just a hodgepodge of features, just things that make absolutely no sense at all, but they include everything under the sun, including your invention and a lot more. What we found from discussions with the examiners is that the drawings can really tell a story on their own. And a lot of us know this already. I'm sure that many of us have seen, you know, a first and a second figure that's provided in a patent application that illustrates the prior art. That's not what the examiners were talking about here. What they were asking for was simply context or environment, or, you know, present the drawings to me so that I can just look at it and instinctively know what part of the world am I in? I mean, what am I looking at as just a technological subject matter? So there are certain benefits to putting these drawings in beyond, I'm going to come back to this in a second, but there's come back to the way the examiners look at drawings. There's certain benefits to looking at, to putting drawings in that tell a story. So a lot of examiners do flip searching. That's what you called searching before we had electronic searching. So examiners would literally flip through the references to find out what to apply to an application. And it's rare that they're looking at the text of the drawing. They're looking at the text of an application. They're looking at the drawings first. And if they can get a sense of what the invention is just by looking at the drawings, then that helps you actually. If you have an issued patent that could be used as a reference, or if you have a published patent application that an examiner is relying on to reject a competitor's patent, and your drawings are not in good shape, he's going to flip over past your application, which could have been used to provide an anticipation or obviousness rejection for a competing patent. So drawings have a number of different benefits to examiners beyond them just understanding the invention. It's the practical use as well. I want to give you an example of what I'm talking about here. These are a couple drawings here. Oh, wait a minute, I'm going to go back. Yeah, okay, these are a couple drawings here. I'm going to just give you 10 seconds and take a look. Let me know if you know the context of the invention. All right, so 10 seconds, it's probably way too much time. If anyone was born in the 80s, 90s, or even the last 5 years, you probably can figure out that figure one is the back of a pickup truck. And it doesn't take my experience in the automotive industry to know that figure two is probably the deck lid or the door to the truck bed of the pickup truck. So you have the first flap or the first platform, and you also have a second platform that rotates down from the first one. So I already know at least the environment of the invention. I know what general area we're talking about now. So I move on to figures 3 and 4, and I also now see that there's a third flap that comes down from the second. So I'm in the mindset that this is probably a step or some sort of shelf that could be used for access to the truck bed. Not only that, in figure 4, I even can see how the hinge is put together and all that. Now, I acknowledge that this is a mechanical invention. It's a lot easier than, say, a processor claim when you have to show flow charts and things variables happening here and information being exchanged from one place to another. But the point nonetheless remains, we are trying to provide the examiners with context to make prosecution a lot easier and a lot less, less protracted and a lot cheaper. I'm going to show you another set of drawings. I'm going to give you 10 seconds to figure out, see if you can figure out what this one is. So this, my title's not up here. You can't really see it, but what this says is, what the title says is something about drawings without environment. And what we're looking at here, you would have to be, even the title doesn't help you with this if you're not in this particular technology. The title of this is a sleeper, and to know what this is, you would have to be in the railroad technology. What these things are actually railroad ties that you would see, you know, on railroad tracks. I still don't know. I still don't know what the context is. You know, railroad ties have been around forever. So what are we getting at here? So there are 6 figures in this drawing. I'm going to just take us through them right quick. So this is an end-on view of the sleeper of the railroad tie. And then finally we get to the last figure, figure 6, and this is the railroad tie in use. I don't know what this is still, and maybe you all do, so maybe it's just my lack of experience with railroad ties, but it looks a little confusing to me. I'll let you off the hook. It wasn't until I got to one of the dependent claims that I figured out exactly what this thing was was getting at. The railroad tracks are elements 27, the tie is 1, and 11 is a cable. So the purpose of the invention is to protect electronic equipment that has to be laid across railroad tracks. There's no way I could figure this out from the drawings. I had to go into the detailed description to figure it out. So this is kind of what I'm getting at, is we have to give examiners context if we're going to reduce the length of prosecution and the cost of prosecution. So let's get into the claims. I want to try to move as fast as I can because I know I have a limited amount of time. Let's get into the claims. How do claims prolong prolong prosecution and increase the cost of prosecution? Well, let's talk about how to keep them from prolonging prosecution. Well, first you have to know your art unit. Different technology centers have different expected practices. So it's important that we as practitioners identify the art unit that we expect the application to end up in so we can draft claims and the application in a way that the examiner expects to see it. So I'll give you an example. While functional language is acceptable in processor claims, and it's acceptable in mechanical claims as well, you have to understand in the mechanical arts, examiners give it a little bit less weight than they do in the processor arts. They have to consider it, but the examiners we spoke with will often overlook the functional language if they can find the means or the device or an apparatus that can be adapted to perform that particular function. Now, that's notwithstanding what the law says. I know there was a case a couple of years ago that says that examiners should have to look at those things, give that functional language weight. What's happening in practice is different from that law, though. So probably the most important thing about avoiding prolonged prosecution, though, is to have those claims in good order when they're produced, when they're presented to the examiner. So the biggest complaint amongst examiners that I encountered was applicants often waste a first office action. And by that, what they meant was they spent a lot of time getting claims and the application really in the condition that they would have wanted to see it when it gets to the office. So think about that. If you're spending a lot of time wasting a first action, you're spending a couple $1,000s on the response just to get the examiner to understand the invention. It's not until the second response that you are now getting a real true substantive review. And by then the examiner doesn't even have to comment on your invention. You might have, now you're faced with potentially having to file an RCE, and that increases costs even more. So it's these little, I don't want to call them quirks, these little disconnects between practitioners and examiners that we really have to pay attention to. I'm going to give you a couple of, let me give you some sample claims here, and I'm going to try to wrap up. So on the next slide, we're going to have a look at a couple of claims, and the claims are going to be directed toward a table. And the dictionary definition of a table is an article of furniture consisting of a flat, slab-like top supported on one or more legs or other supports. One of the complaints amongst examiners is the submission of two-line claims. And I know why we do this as practitioners. Like I said earlier, I have an eye on the present and an eye on the future. I don't want to submit a claim with words that could be used against me in court. Examiners can't stand that though, because what ends up happening is I have this claim here, a table comprising a planar surface having a maximum 0.1% load-bearing deflection. I know this might be directed toward the novelty of my invention, that this table can withstand whatever load possible. The problem is, this brings in a whole host of prior art that we, when we were drafting the claim, probably didn't anticipate. So, give you an example. The kind of things that an examiner might cite against me on this are not only a table, but now we're talking about like a forklift fork, which is is a planar surface that probably has less than 0.1% load-bearing deflection. Gosh, what else? I'm thinking about more automotive references, like a car jack or something like that, that when they hoist your car on a lift. Heck, the foundation of your home is a planar surface that has less than 0.1% load-bearing deflection. So you get all this prior art that's involved, and examiners say that. They'll tell me that if you can provide context of the invention, not necessarily what the prior art is, but just put the invention in terms that help narrow their search a little bit. They can get through it faster. They can provide the best prior art. We can end up with a better patent at the end of the day. I'm going to show you one that's on the opposite side of what we're talking about here. So now we have a table comprising a planar surface having an underside and an upper side. The planar surface supported by at least one support beam attached to the underside and having a 0.1% maximum deflection under a load on the upper side of at least 2 tons without substantial deflection. This is a little bit too much. This is not what they're talking about. This is adding more features that really should be recited in dependent claims. What they're talking about is add those features that used to be in the preamble. So the preamble is supposed to take care of the requests that the examiners are after now. The preamble is the introduction of the subject matter. They're really saying, well, just go ahead and put it in the claim. If it's a necessary part of the invention, and I'm not saying you need 2 support beams for a table, but they're saying if it's something you can add without necessarily narrowing the scope of your invention, please put it in so it helps me narrow my search. That was a request I had of the examiners. I acknowledge I'm a practitioner. I'm going to be fighting with examiners on this for probably the rest of my career, but at least knowing this will help reduce costs for prosecution in the future. So what is the objective at the end of the day? One of the things we're trying to do is, like I said, obviously reduce costs. One of the things that increases cost is additional requests for continued examination. Well, if you're starting with an office action that is only helping you put the application in condition for the examiner to understand the invention, you're already behind the 8 ball. You're already at a disadvantage. So we want to try to prevent that from happening. Actually, I want to go back and talk about one more thing. I'm sorry. Okay, I'm going to do this real fast. I highlighted substantial here. And for the practitioners in the room, you've probably seen this many times. One of the complaints of the examiners was the use of adjectives, that adjectives are often relative. So substantial has an accepted definition amongst many practitioners. Many examiners will let it go. But there were some examiners who say, if you use that term in a claim, I'm going to reject you based on indefiniteness. So you have to give me a range. And if you don't have a range, then you have to take that out completely. Or if I said the term rigid, or if I said the term about, or anything that is a relative term, they have a problem with. So I just wanted to also point that out. That's why that was highlighted, and that phrase applied at any point on the planar surfaces it was weird, but examiners also want to know how did this thing, even though it's a structural claim, I want to know I want a little bit more context to where the load is applied. If you add a if you're reciting what the objective of the invention is in the claim, show me how you get it in the claim. I think that's a little too much. So that's a discussion for another day. Anyway, so I really want to reduce cost if possible. How do we do that? The way to do that is not to do some of the things you saw today. I'm happy to talk a little bit more about some of the other things we talked about, for example, with information disclosure statements and submitting references, how to properly use interviews. That was something we discussed at the partnership meeting a couple of weeks ago. There were some restriction requirements. I think, Guy, you and I talked about that a couple of nights ago. Restriction requirements are something that we as practitioners just don't get. And the examiners, I'll say this a little bit tongue-in-cheek, they simply said, look, if I don't have the time to examine it, I'm going to restrict it out. They were kind of joking on that one. There were some more particular reasons that they issue restriction requirements. The point is, look, with all of the attacks on patents that are available to people now, there's no point in providing more ammunition. IPRs are kind of going crazy right now. People are losing patents for a number of different reasons, usually for anticipation and obviousness. But why have other problems in there from day one of filing? So again, the title of this discussion really should have been greater context, less cost. Greater context, less cost. When you go home tonight, and if this happens to come up in your mind, that's what I want you to think of. Greater context, less cost. And there's a little bit of a disconnect between examiners and practitioners, but if we can come a little closer, maybe we can still get the broad coverage, but make the examiners happy too, and I'll be happy. So that's my presentation. Thank you very much.